Yes. What's your name? Unmute yourself, unmute your system. You are muted. Check it. Your audio is muted, unmute it. Very well, go ahead.
Thank you, my lord.
Yes.
Yes, M.O. Idigbe is my name. My appearance is for the claimant.
Any other appearance? Kneel for the defense?
No, my lord.
DR, kneel for the defense. Unmute your phone.
Yes, my lord.
Did you reach out to the defendants or counsel? Okay, and you have proof?
Yes, my lord.
Very well. So judgment is ready and I'm going to deliver it right in here.
As the court pleases.
Here is the judgment of the court. A perusal of the originating process conveys that this action is a declaratory one. The law is of common that a party who seeks a declaratory relief must rely on the strength of his own case to prove that he is entitled to the relief sought. Thus, a claimant who seeks a declaratory relief needs to satisfy the court on the balance of probabilities to be entitled to same. As such, declaratory reliefs cannot be granted in the absence of credible defense or on admission of defense, but on satisfactory and credible evidence by the claimant. See the case of Ufongo and APC citation captured, the case of Adamu, Nigerian Air Force citation provided, the case of Adeshina Air France citation provided, case of PDP and INEX citation captured. However, the law does not preclude such a claimant from relying on aspects of a defendant's case which support his own. See the case of Hanatu and Amadi citation is captured. Claimant in this case filed his general form of complaint on 17 May 2019, but same was subsequently amended and filed on 2nd of July 2019, wherein claimant seeks the following reliefs against the defendants. 1, a declaration that the termination of the claimant employment with the first defendant is unlawful, illegal, void, and of no effect, same having been carried out in flagrant disregard to the first defendant's condition of service as provided for in her organizational handbook. 2, a declaration that the claimant is still in the employment of the defendants and as such entitled to all his salaries and allowances from the first defendant until they resort to first defendant's condition of service in disengaging the claimant. 3, general damages of 5 million naira only against the defendants for the emotional torture arising from the period the claimant was left hanging without work and the unlawful disengagement of the claimant, and 4, cost of filing and prosecuting the suit. It is the claimant's case that he was an employee of the first defendant, an operator, but was detailed to the second defendant to work with Dangote Coal Mining, Ankpa, Kogi State. But he was sometimes arrested and detained for 9 days by the police following an allegation of criminal breach of trust. He was subsequently arraigned before a court and was discharged after being exonerated of the allegation, but despite his exoneration and discharge, he was asked to stop work, which persisted for over 9 months. He therefore retained the service of a law firm to write the defendants, but yielded no result. He subsequently caused his lawyer to write the defendants a detailed correspondence. He was later called upon to resume work on 25th of February 2019 with the promise to pay all his arrears of salaries. Pursuant to this, he resumed work, worked for a month in March, and was paid salary for the said month, but was later served with a letter of disengagement. He stated that he was not given any period of notice or salary in lieu of notice in flagrant disregard of the condition of his employment as provided in the organizational handbook of the first defendant. However, after the termination of his employment, the defendants paid him the sum of 573,156 naira 4 kobo without description of what it was actually meant for, which amount is short of his outstanding salaries for 10 months. He also averred that he was never queried nor suspended without the period throughout the period of his employment. The defendants on their part filed their joint statement of defense, wherein they admitted claimant's averment in his amended statement of facts as regards his employment relationship with the defendants. They continued that Dangote Coal Mine Limited, where claimant works, and the second defendant are subsidiaries of the first defendant. They stated that claimant was employed by the first defendant and worked at its Obajana plant until it was transferred to work at the second defendant's coal mine at Ampa. That once an employee is being transferred to the coal mine, he's deemed to be under Dangote Projects Limited. The second defendant, as it is the same company as Dangote Mine Limited. They equally aver that they are unaware of all what transpired between claimant and the police as well as the court. It is equally part of their statement that claimant was never asked to stop work, but the claimant's salary was only put on hold pending the determination of a case against him. It was admitted that a letter was received from claimant's lawyer on payment of his 4 months arrears of salary, which letter was honored as the claimant was subsequently reinstated on the 22nd of February 2019 and all his arrears paid. That claimant's employment was terminated for services no longer required on the 4th of April 2019, and 1 month salary in lieu of notice was paid to him, and his arrears of salaries were equally paid to him in full. Finally, they stated that claimant's March salary was paid, including 4 days he served in the month of April. On the 26th of January 2022, parties in this case consented to adopt the argument on record procedure pursuant to the 38 Rule 33 of the NICN Civil Procedure Rules to argue their case on record and dispensing with the need for oral evidence, as it is customary to do in line with the procedure adopted by parties. This court ordered parties to file their final written addresses, claimant filing first. So all that the parties filed have been reduced into the body of this judgment. So I'll go straight to the decision of the court. I've carefully perused the originating process, its statement of facts along with the accompanying processes, the statement of defense, with all its accompanying processes and final written addresses of parties. It is in my humble view that the issues that will best determine this case are: 1, whether claimant's employment is one clothed with statutory flavor, and 2, whether claimant has proven his case to be entitled to relief sought. Respecting issue 1 framed, learned counsel for the claimant made a heavy weather of the argument that claimant's employment is one clothed with statutory flavor in his final written address in this case. I must say that learned claimant counsel clearly misconceived the position of the law on employment with statutory flavor, and I'll proceed to state why. There's no doubt that there are basically 3 types of employment, namely purely master and servant relationship, B, where servants hold the office at the pleasure of the master, and C, employment with statutory flavor. And lately, there's one that has been added to it, and that is a tripartite form of employment. See the case of Controller General of Customs and Gusau, citation capture, the notorious case of CBN and Ibilu, citation provided. And employment is said to be statutory flavor when the appointment or employment and the conditions governing same are contained in the statute or in the regulation made pursuant to the statute. Accordingly, 2 conditions must be met, namely A, that the employer is the creation of statute, and B, the condition of service are contained in the statute creating the employer or in a regulation made pursuant to that statute. See the cases of Forisha Nigerian Gas Company Limited, citation captured, case of PHCN and Ofoilu, citation captured, case of Fakwadi and OAUTH, citation captured, notorious case of Olaniyan and University of Lagos, citation captured, the old case of Ekborokun and University of Lagos also, citation provided. The law is long settled that where the employment contract is reduced into writing and it is not one that enjoys statutory protection, it is no doubt one of master-servant relationship. Claimant's employer in this case is a limited liability company registered under the Corporate Affairs Commission, which fact claimant averred in paragraphs 2 and 3 of his pleadings styled as, I quote, amended statement of claim, unquote, hereafter referred to properly as the amended statement of facts. It is not a creation of statute, neither is it a statutory corporation. Claimant in this case pleaded his letter of employment, which contains some terms and conditions of his employment. He equally pleaded with paragraph 16 of his amended statement of fact, a particular organization handbook of the defendant, which though was not tendered by him. There's no doubt from the facts and circumstances of this case that the claimant's employment, being one governed by the contract entered into between him and the defendants, is one of a master-servant relationship and not one with statutory flavor, as learned counsel for claimant would want the court to hold. Accordingly, issue 1 is resolved against the claimant. Now to issue 2. Claimant in this suit sought the grant of declaratory reliefs. It has been held in plethora of judicial authorities that in the claim for declaratory reliefs, as in the instant case, the claimant must succeed on the strength of his own case and not on the weakness of the defendant's case. The claimant would not be entitled to judgment even on admission by the defendant. It is the duty of the claimant to first prove the existence or non-existence of what he asserted by relevant, admissible, and credible evidence. Once this burden so placed on the claimant is discharged, the onus then shift to the defendant. See the case of Uzodima and Ehedio has citation captured. However, a claimant is allowed to rely on an aspect of defendant's case that support his own. See the case of Hanatu and Amadi, citation captured. The case of Salisu versus Mubolaji, citation captured. The case of CDC Nigeria Limited versus SCOA, citation also captured. Claimant in this case seeks a declaration that the termination of his employment is illegal, void, and of no effect, having been carried out in flagrant disregard of the first defendant's condition of service. It is strike law that when an employee complains of wrongful termination of employment by his employer, he has the onus to prove the wrongful termination of the said employment by A, placing before the court the terms and conditions of the contract of employment, and B, proving in what manner the said terms were breached by the employer. See the cases of Azeva and FBN Mortgages Limited, citation captured. The case of Angel Spinning and Dyeing Limited versus Ajar, citation captured. University of Calabar and STN, citation provided. And the case of Amude and Amode, citation captured. Claimant in this case, as reasoned earlier, pleaded his letter of employment, which is marked as Exhibit M. He equally pleaded a particular organizational handbook, which contains the other terms and conditions of claimant's employment, which he did not tender, but gave the defendant notice to produce. In the case of Ogwebie and FBN citation provided, the court held inter alia that it is the duty of a party relying on documents in proof of his case to present at least secondary evidence of the contents of the documents. In the same vein, the Supreme Court in the case of Ziregbe versus Mimi, citation captured, reasoned that the failure of a party to produce any document that is pleaded could preclude the court from relying on it. Failure of the claimant to present the said handbook, which is relying on in proof of his case, is thus fatal to his case. I am not unmindful of the submission of learned claimant's counsel in his final written address, specifically at page 141 of the record of court, that failure of the defendant to produce the said handbook should be resolved as withholding evidence in section 149D of the Evidence Act 2011 and put into bracket as amended. Let me first state that there is no such thing as Evidence Act 2011 as amended, which learned counsel is claiming to be citing from. The Extant Evidence Act is quote and unquote Evidence Act 2011. In the Extant Evidence Act, presumption as to withholding evidence is contained in section 167 paragraph D of the Evidence Act and not section 149D. The doctrine of withholding evidence as contained in section 167D of the Evidence Act has its root in the Latin maxim, omnia presumptor contra spoliatorem, which means that, I quote, all things are presumed against the wrongdoer, unquote, can be invoked where an evidence which could be is not produced. It will be presumed to be against the party withholding it. See the case of Edosa and Ehiwema, citation captured, the case of Euba and the state, citation provided, the case of Smart and the state, citation also provided. It must be borne in mind that failure to produce a document pursuant to the service of a notice to produce cannot be resolved as withholding evidence. The Apex Court in the case of a wager OM Oil Industries Limited, citation provided, Fasasi and Zamfara State Government in another citation provided held that the service of a notice to produce does not compel the party served to produce the document, rather it entitles the party serving the notice to adduce secondary evidence of the document in question. See also the case of Buhari and Obasanjo citation captured. It is obvious from the plethora of case law authorities that failure to produce pursuant to a notice to produce only entitles the party serving the notice to adduce secondary evidence of it. In fact, the Apex Court in the case of Abimbola and the state citation provided held that failure of a person to produce a document after being given notice to produce cannot be resolved as withholding evidence, as Section 91 of the Evidence Act that deals with notice to produce does not relate to Section 167 of the Act, that which deals with withholding evidence. Thus, it is clear that the defendants cannot be compelled to produce the said organizational handbook, and neither can the failure of the defendants to produce same be resolved as withholding evidence. From the foregoing, it is clear that the only document before the court which this court can rely on in the absence of the handbook is the letter of appointment in proof of the terms and condition of employment of the parties. Claimant in this case, be it paragraph 16 of the amended statement of fact averred that he was not given any notice, neither any salary in lieu of notice in flagrant disregard of the condition of employment contained in the handbook. The defendants, be it paragraph 12 of the statement of defense, stated that claimant's employment was terminated for services no longer needed, and 1 month's salary in lieu of notice was paid to him. The defendants relied on a document titled Appendix A. The claimant in response, be it paragraph 6 to 7 of the reply, averred that shortly after he was disengaged, the defendant paid the sum of 573,566 naira 4 kobo into his account without description on the 9th of April 2019. And when he approached the account section of the defendant for clarification, he was told that the amount paid to his account represented his salaries and arrears for over 9 months, having unilaterally deducted his indebtedness to their cooperative in error. Claimant relied on his statement of account together with his certificate of compliance, marked here as Exhibit M4. The law is common that in a master servant employment where parties have reduced the terms and condition of service into writing by way of contract, the terms must be observed and complied with by parties. This is because the common law recognizes and protects sanctity of contract, pacta sunt servanda. The position of law as regards master-servant relationship is clear, as the law sees it as a contractual one governed by the terms and condition of employment. See the case of Oak Pensions and Olayinka citation captured. As such, where the employer wishes to terminate employees' employment, he must do so in accordance with the contract entered into by parties. See the cases of Organ and Others versus Nigeria, Liquefied Natural Gas Limited, citation provided. The case of Lunga and FBN, citation provided. In the case of Keystone Bank Limited versus Clark, citation captured. The appellate court, per Nimpa JC, quoted with approval the decision in the notorious case of Olani and Others versus Unilag and another Supra, and held that just like other contracts, contract of employment's creation and termination are subject to the general principle of contract. As such, where the terms of contract are in writing, parties are bound by the express terms of their contract. The duty of the court in such instance is to interpret the terms of the contract of the parties and give effect to it. See also the case of Sahara Energy Resources Limited versus Mrs. Oyebola, citation captured. The case of Omega Bank Nigeria PLC versus OBC Limited, citation also captured. The court in interpreting the terms of the contract between parties must give the words their plain, ordinary and natural meaning, where the words used are clear and unambiguous. In the case of SZ Petroleum Enterprise Nigeria Limited and Petroleum Equalization Fund Management Board and another citation provided, the court held that where the words used in the contract are clear, the operative words in it should be given their simple and grammatical meaning. See also the case of SCMB versus John Andy and Sons Company Limited, citation captured. I've reasoned earlier in this judgment that claimant failed to tender the handbook that provided for giving of a notice before termination. The court, however, does not lose sight of the fact that the letter of employment Exhibit M, which also, as I've stated earlier, forms the bedrock of relationship between parties, also contains a provision for a notice period. This fact was equally alluded in the final written address of the defendants. The letter of employment Exhibit M, being a document, will speak for itself. See the case of Olukemi and Airtel Networks Limited citation provided, the case of Asuku and another versus Omali and another citation provided. I peruse the said Exhibit M and it provides thus as regards notice, I quote, both the company and you can terminate the employment by giving 1 month notice or paying 1 month salary in lieu of notice. However, during the probationary period, the notice period shall be 2 weeks on either side, unquote. It is clear from Exhibit M that the employment relationship can only be terminated by giving 1 month notice or 1 month salary in lieu of notice by either the claimant or the employer. But where the employment was terminated during the probationary period, the employment can only be terminated by 2 weeks notice from either side. From the pleadings of the claimant and the evidence on record, particularly in Exhibit M1, it is clear that claimant is a confirmed staff of the defendants. As such, the 2 weeks notice period would not apply in this case, but the 1 month notice period. Thus, it is without doubt that claimant is entitled to 1 month notice or 1 month salary in lieu of notice at termination. I do not lose sight of the fact that learned counsel on behalf of the claimant in his final written address, pages 141 and 142 of the record, refer the court to several portions of the said handbook on disengagement, which provided also for 1 month notice or 1 month salary in lieu in the event of termination. As reasons supra, claimant did not tender the said handbook, which is part of the documents being relied on. Let me remind learned claimant counsel that address of counsel, no matter how beautifully written or done, cannot take the place of evidence where there is none. See the cases of Angadi and PDP, citation captured, Uyemi and Uweye, citation provided, the case of Agbaruka and FBN Limited, citation provided. The address of learned counsel wherein he quoted section 7 of the handbook, a document that is not before the court, providing for 1 month's notice cannot take the place of evidence, which is the handbook, which was not tendered in this case. As such, that portion of the address of counsel is of no relevance in this case and thus is countenanced. Claimant in this case had maintained that he was asked to stop work and which state of affairs persisted for over 9 months. The defendants on their part in their joint statement of defense denied the assertion of the claimant that he was asked to stop work. They contended that the company's human resource only ordered that claimant's salary be stopped. They rely on Exhibit D4. This fact was equally reiterated in the statement on oath of DW1 Yahaya Zakari Jubril. However, this court finds from a perusal of the exhibit, particularly Exhibit D3, an internal memo titled, quote and unquote, reinstatement and payment of arrears of salaries of Moses Ibrahim, in bracket, Ankpa staff, unquote. Recalling claimant's early clearly shows that claimant was ordered to be reinstated and called back to work from suspension as evinced on the memo. The question that requires an answer here is, if claimant was not asked to stop work as contended by the defendants, how come Exhibit D3, which was tendered by the defendant stating that he should be recalled to work and be paid all his salaries from the period of suspension from work to the date of the memo? It is a standing principle of law that oral evidence will not be allowed to contradict or impeach documentary evidence. See the cases of Arije and Arije order citation captured, Facomiti and Ilorian and other citation captured, Michael Dan Udo versus Chief C. Udom Eshiet citation also captured. The ipsi dixit of DW in paragraph 10 of his written statement on oath cannot be allowed to discredit clear contents of Exhibit D3, showing that claimant was reinstated and recalled to work and was to be paid his arrears of salaries from the period of suspension to the date of the memo. Thus, the ipsi dixit of DW1 DW in paragraph 10 of the statement on oath is of no evidential value, as same cannot impeach or alter the content of Exhibit D3, I so find and hold. Now to the contention between parties about the payment or non-payment of 1 month salary in lieu of notice. Claimant on his own part maintained that he was not paid 1 month salary in lieu of notice, contrary to the assertion of the defendants that the sum of 573,566 naira 4 kobo, which was paid into his account on 9 April 2019, represented salaries and arrears for over 9 months, the defendants having unilaterally deducted his indebtedness to cooperative in error. Claimant supported this assertion with Exhibit M4. The defendants on their own part maintained that claimant was paid his 1 month salary in lieu of notice and relied on Exhibit D, which is a list of full and final settlement of claimant. This court believes the assertion of the claimant that the said sum that he was told by the account section that the money was for his arrears of salaries after unilateral deduction of his indebtedness to the cooperative, and I will explain why. Claimant had earlier averred in paragraph 18 of his amended statement of facts that the said sum of 573,556 naira 4 kobo was paid to him as his arrears of salaries, but same fell short of how much he is entitled to. The defendants, in response, by paragraph 14 of their joint statement of defense, responded that the said sum represents claimant's full and final settlement for his arrears of salaries, which facts were equally reiterated in the witness statement on oath of DW. Is it a tried principle of law that documentary evidence is a hanger on which to assess oral evidence? See the following cases. Emeka versus Innocent and others citation provided. The case of Oyewusi and others versus Olagbami citation provided. The case of First Bank and Azif Waku citation provided. Peru's Exhibit M4 relied on by the claimant, and it is clear that truly on the 9th of April 2019, Dangote Coal Mines Limited did transfer the sum of 573,556 naira 4 kobo to the account of the claimant, but there was no description of what it was meant for. It should be noted that Exhibit D3 relied on by the defendants states clearly that claimant has been reinstated and that he is to be paid his arrears of salaries from the date of suspension to the date of the letter, which is February 22, 2019. Also, Exhibit D2, document titled quote and unquote fund transfer, which was also relied on by the defendants in this case, authorized Access Bank, the bank of Dangote Coal Mines Limited, to debit its account with a sum of 573,556 naira 4 kobo in favor of the claimant through his guaranteed trust bank account, which this court finds to be the same amount that was credited to claimant's GTB account on the 9th of April 2019, as seen in Exhibit M4. It is thus clear, without any shadow of doubt, that of a truth, the sum of 573,556 naira 4 kobo was paid as claimant's arrears of salaries, as alleged by him and as deducible from Exhibit D3 and D2 and D3 respectively tendered by the defendants. I've equally perused Exhibit D relied on by the defendants in support of the assertion that claimant has been paid his 1 month salary in lieu of notice together with the above payment. And I can categorically say that the exhibit is just a breakdown of claimant's entitlements. There's nothing in the said exhibit that shows that the claimant was actually paid the sum of 94,815 naira 17 kobo calculated in the exhibit. It is merely a breakdown and nothing more. It doesn't show claimant has been paid as alleged by the defendants. It is merely a breakdown as the document speaks for itself. In fact, the stamp on it shows that the audit department of Dangote Group passed same on the 9th of May 2019, which date is clearly a month after claimant's employment was terminated, which was on the 4th of April 2019. The court in the case of Bolu and Federal College of Education, Obudu, and another citation captured held that the burden of proving payment of salary in lieu of notice lies on the party asserting the positive, which is the employer, in line with sections 131 and 132 of the Evidence Act. and that the employee assertion of a negative does not place any such burden on him. That the employer has the burden to prove that the employee was actually being paid or was actually paid. The defendants herein are duly bound to show that they actually paid the said sum to the claimant. There was no such evidence before this court. The defendants who have this burden has failed to prove or substantiate their assertion that claimant was paid in view, that claimant was paid in view of the reasoning above, that there is nothing in SBD to show that claimant was paid or that the said sum was paid to his account. I hold that claimant has not been paid. I'm mindful of the submission of learned counsel on behalf of the defendants on issue 2 formulated in his final written address that the defendants have been able to show that claimant was paid 1 month's salary in lieu of notice, and they refer the court to Appendix B, which shows that claimant was paid 1 month's salary for March and 4 days in April, which is herein as Exhibit D1. Let me first state that the defendants in his pleading, specifically by paragraphs 12 and 13 of the defendant's joint statement of defense, stated that the claimant was paid 1 month's salary in lieu of notice, and the document embracing payment is Appendix A, which is herein admitted as Exhibit D. In fact, the defendants went further in paragraph 14 of the same joint statement of defense to plead that claimant was paid his March salary, including 4 days he served in April, while pleading and relying on Appendix B, herein as Exhibit D1. It is thus clear from the pleadings of the defendants that the sum paid to claimant in Exhibit D1, referred to as Appendix B in counsel's address, represent claimant's salary for the month of March and 4 days in April, in which he worked different from 1 month's salary in lieu of notice, in proof of which they are relying on Exhibit D1. The averments of the defendants are clear to the effect that the document showing claimant was paid 1 month's salary in lieu of notice is Exhibit D, and not Exhibit D1, as learned counsel would want this court to believe. In the case of Ozongbaji and Amadis and others, citation captured, the Apex court held that parties are bound by their pleadings and the party will not be allowed to set up a case different from its pleadings. See also the case of Young Shall Grow, Motors Limited versus Onalaja, citation captured, and the case of Shogunro and Yeku, citation also provided. As such, parties, including their counsel, cannot orbit outside the compass of the issues so joined in their pleadings in search of a more luxurious facts. It is wrong of learned counsel to be trying in his address to mislead the court by setting up a case different from the one set up in the defendant's pleadings, as there was nothing in the pleadings of a party that says that the amount paid to claimant as salary for March and 4 days in April represent his 1 month salary in lieu of notice. Besides, it is clear from the facts averred by parties and the evidence before the court that claimant worked for March 2019 and 4 days in April, and those entitled to be paid for the work done. He did not, sorry, just a minute. He did different from, sorry, let me take that again. Besides, it is clear from the facts averred by parties and the evidence before the court that claimant worked for March 2019 and 4 days in April, and those entitled to be paid for the work done, he did differently from 1 month's salary in lieu of notice provided for in his letter of employment. In view of all reasons supra, I find that claimant was not paid 1 month's salary in lieu of notice, which is entitled to before termination of his employment by the defendants. Failure to pay the 1 month salary in lieu of notice is in breach of the term of his contract. In the case of Ibama and SPDC, Nigeria Limited, citation captured, Onaga JSC, CGN now retired, held, and I quote, except in employment governed by statute wherein the procedure for employment and discipline, including dismissal of an employee, are clearly spelled out, any other employment outside the statute is governed by the terms under which the parties agree to master and servant. In other cases, governed only by agreement of parties and not by statute, removal by way of termination of appointment or dismissal will be in the form agreed to. Any other form connotes only wrongful termination or dismissal, but not to declare such dismissal null and void, unquote. See also the case of Cato and CBN citation provided. Claimant in this case, in his first relief, seeks a declaration that the termination of his employment is illegal, void, and of no effect, having been carried out in flagrant disregard of the first defendant's condition of service. I've held that the claimant's employment is not one that enjoys statutory protection, but one of a master servant employment. It then means that in line with the above judicial authorities, termination of such employment, even where found to be contrary to terms and conditions of employment, cannot be declared as unlawful but wrongful. Accordingly, claimant's first relief succeeds to the extent that termination of claimant's employment is wrong for being in breach of the terms of his contract. I so find and hold. Noteworthy is the fact that learned counsel on behalf of the defendants in his final written address kept referring to the severance of the employment relationship between parties in this case as dismissal. Need I remind learned defense counsel that there is a whole world of difference between termination and dismissal. While in termination of employment, the right to terminate is mutual and most times entails the right to notice and there is equally no loss of accrued benefits. In dismissal, there is no right to notice and there's equally loss of all benefits as it is a disciplinary or punitive measure. See the case of Ekwala and CBN citation capture, the case of UBN PLC and Soros citation capture, the case of 7-Up Bottling Company Limited PLC and Augustus citation provided. Exhibit M2, which is the document evincing severance of relationship, clearly shows that claimant's termination is not in consequence of any disciplinary or punitive measure, and that claimant was entitled to benefits and entitlements, if any, as stated clearly in that letter. It is thus clear that the severance of the employment relationship, as rightly referred to severally in this judgment, is termination and not dismissal, as learned counsel on behalf of defendants termed it in his final written address. I so find and hold. Claimant in his relief 2 seeks a declaration that he is still in the employment of the defendants and as such entitled to all his salaries and allowances until defendants resort to the condition of service. It is tried that in a master-servant relationship, where termination is declared as wrongful as in this instance, the employee cannot choose to treat his employment as still subsisting and decide to claim for salaries beyond the period of termination. This is because the fact that the termination of a servant is otherwise than in accordance with the procedure laid down in his contract of service does not, however, in the case where the rights of the parties are regulated by contract, normally prevent the termination from being effective termination of contract. The only remedy available to the employee is a claim for damages. This is based on the notion that no servant can be imposed by the court on an unwilling master, even where the master's behavior is wrong. For this wrongful act, is only liable in damages and nothing more. See the cases of Forisha Nigerian Gas Company Limited, Supra, Ekwala and CBN Supra, Olariwaju and Afribank Nigeria PLC, citation captured, Dr. Chukuma versus Shell Petroleum Development Company of Nigeria Limited, citation captured. Thus, relief 2 fails. Claimant in his third relief claims for the sum of 5 million naira as damages. It is tried that at common law, the measure of damages for wrongful termination is how much the employee will have gotten or earned over the period of notice. Say the case of Babaye and UBN citation provided, Bobo and British Airways PLC citation provided. In the case of Sahara Energy Resources Limited and Olaomi Ebola Supra, the appellate court per Ogaku JCA had the opportunity to decide on the common law orthodoxy on the quantum of damages for termination of employment and held inter alia, thus I quote. In the circumstance of this matter, where the dismissal of the respondent was predicated on allegations bordering on dishonesty and bribery, which no doubt carries a stigma, it is what will form the base in considering the measure of damages to award in tune with international best practices. In this wise, there is the progressive decision of this court in the case of British Airways and Makanjuola, delivered way back in 1993, which affirmed the award of 2 years' salary as damages by the trial court. In the said case, it was held that the quantum of damages recoverable by an employee depends on whether the wrongful termination of employment was as a result of failure to give the required notice or as a result of an alleged malpractice, and if the former, the quantum of damages may be the employee's salary in lieu of notice, but if the latter, then since such termination carries with it some stigma on the character of the employee, he shall be entitled to substantial damages far beyond the payment of salary in lieu of notice. Accordingly, I will be a differential to the general damages awarded by the lower court in the exercise of the jurisdiction to apply international best practices, unquote. Flowing from the above, it means that if wrongful termination is as a result of failure to give required notice, the quantum of damages may be employee salary in lieu of notice. But if, as a result of alleged malpractice or misconduct which carries with it stigma, the employee is entitled to substantial damages. Although there is evidence in this case to show that claimant was alleged to have committed criminal breach of trust against the defendants and was subsequently acquitted of same. There is no evidence before this court to show that the termination of claimant's employment had anything to do with the alleged crime of criminal breach of trust, which will have meant that such termination carries a stigma on the person or character of the claimant, in which case he will be entitled to substantial damages in line with international best practices. In fact, from the facts and circumstances of this case, claimant was recalled to work after some time and was even paid all his arrears of salaries as reasoned earlier in this judgment. Also, Exhibit M2, the letter of termination is clear in that claimant's employment was terminated because his services were no longer required. Claimant in this case ought to have gotten 1 month's salary in lieu of notice of termination, which the defendants failed to give. I find that the quantum of damages which claimant is entitled to is his 1 month's salary in lieu. Exhibit M, the letter of employment evinces that claimant's 1 month's salary is 57,760 naira per month. Accordingly, I find that claimant is entitled to the sum of 57,760 naira as damages for wrongful termination. I so find and hold. Claimant by his fault relief claims for the cost of litigation. Claimant did not assess the cost, but passed on the burden to the court. The position of the court, as seen in the decision of Apex Court in Mekunya and Emirates Airlines Supra, is that cost, including cost of litigation, is at the discretion of the court once empowered by its rules. This court has similar copious provisions as that of the Federal High Court in that relied upon by the Supreme Court in the case of Mekunya Supra. The rules of this court, particularly of the 55, empowers the court to grant cause of action at its own discretion. The discretionary power of this court is to be exercised judicially and judiciously. The claimant in this suit did not assess the cost, rather, as I've stated earlier, rather he passed on the burden to the court. Considering the history and length of this case, the number of appearances in this case, and the number of processes filed, I will in my discretion award the claimant a reasonable cost of action. In exercise of that discretion, I award a sum of 200,000 as cost of litigation in this suit. For the avoidance of doubt and reasons earlier given, I declare an order as follows. 1, the termination of claimant's employment is wrongful for being in breach of the terms of contract. 2, claimant is entitled to the sum of 57,760 naira as general damages. 3, claimant is entitled to the sum of 200,000 naira as cost of litigation. 4, this judgment is to be complied with within 14 days of the delivery of this judgment, which is today, failure of which it would attract 10% post-judgment interest per annum. Judgment is accordingly entered.
Hello, my lord. We are most grateful for a well-researched judgment. No doubt we are better informed now that we were when this matter commenced, and we take due advantage of all that we have learned from this judgment. May you please, my lord. Still there.